Okay, I think if there are still people joining, we'll let them slowly trickle in. I hope they don't miss much, but if they do, they can always rewatch the recording. For now, I think we'll get started, Matthias and Linda. And yeah, so good morning, everybody. And I want to give you all a very warm welcome to another edition of a Cross-Border Claims webinar. This time it's being brought to you by the Van der Meijden Benelux region, or more like BeNe region, I guess, today, as we will be focusing on similarities and differences between a number of topics, as you'll see later, in both the Netherlands and Belgium. So without further ado, let's kick this off with an introduction to our two experts who will be hosting this webinar today. As you can see, Linda is from the Netherlands, and she's represented by dark blue, as the Netherlands will be throughout the remainder of this webinar. And Matthias is from Belgium, which will be represented by that turquoise blue in the following slides. So please take it away, you two, and tell us a bit about yourselves.
Good morning, everybody. I am Matthias van den Bos, 34 years old, and I live near Mechelen together with my wife and two little kids. When I'm not working or playing with my two little kids, you will probably find me on a hockey pitch. On a professional level, Van der Meijden is basically my first employer, and I joined them almost 10 years ago. In these 10 years, I've had the privilege to take up different roles. I first started as a claims consultant or Van der Meijden interim professional, and it was during this time I had my first experience with cross-border claims. After 3 years, I had the opportunity to join the business development team, where I was responsible for sales and marketing in Belgium and Luxembourg. 5.5 years and too many sales pitches later, I was asked to take up the role as a team manager for foreign claims and international business. An offer I was happy to accept, of course, and that's how I ended up here giving this webinar.
Welcome, everybody. My name is Linda Sandberg, 58 years old, and I started as a claim handler at a broker in 1988. After changing jobs to several insurance companies, I started in 2007 at Van der Meijden in the Netherlands at the Foreign Claims Department.
Wow, 1988, I wasn't even born yet. Let's get started. So let's have a look at the content. We have picked these 12 topics to discuss. We're not going to go in details because that would take too much time. But should we get started, Linda?
Yes, let's do it. And let us begin with the topic of witnesses. In the Netherlands, a driver is not seen as a witness, and regardless of partisanship, anyone else may act as a witness. However, a statement of an impartial witness has more value than a statement of a partisan witness. So in most cases, statements from partisan witnesses are accepted out of court. Anonymous statements cannot be accepted, and it's only up to a judge to assess the value of statements of witnesses at his own discretion.
Okay. Well, in Belgium, not only the statements of drivers are excluded, but also the statements of passengers or anyone with any relationship towards any of the parties involved. For a witness statement to be accepted, the personal details, such as the full name, address, and preferably phone number and email, should be written down on the ARF or accident report form. Or, of course, the witness is mentioned in a police report. So we already see some differences, but what about merging? Do you have any specific regulations in the Netherlands about merging? Because of all the traffic jams and also the lack of courtesy in Belgium, we felt the need to adopt a rather new article in the Highway Code, Article 12 bis. This article states, and I quote, "When traffic is congested, drivers in a lane that stops or on which further driving is prohibited may only merge into the adjacent free lane immediately before the narrowing. Drivers in that free lane must give priority to one merging driver immediately before the narrowing. In case driving in both the left and right lanes is prohibited, priority must be given first to the one driver in the right and then to the driver on the left lane?
Well, in the Netherlands, merging is a special maneuver and regulated by Article 54 of the RVV. And it says drivers performing a special maneuver, such as driving off, reversing, leaving an exit, driving from a road into an entrance, turning and merging, must give priority to other traffic.
Okay. Another recent article we adopted is the obligation to form a rescue lane when traffic is congested. Article 16.2. Always and on all roads with at least 2 lanes in the same direction, drivers spontaneously form a rescue lane as soon as a traffic jam begins to form, even if no priority vehicle is approaching from behind at that time yet. Do you have a similar rule in the Netherlands, or?
No, a rule like the one in Belgium is not mandatory in the Netherlands. However, we do have a sign that says that if the rush hour lane is open or if there's no emergency lane, always make sure you make room for priority vehicles, but only if a priority vehicle is approaching. The rule we have regarding emergency lane is that you are only allowed to drive on the emergency lane in case of an emergency. And driving on the emergency lane without an emergency may call for a fine. And that is right now 420 euros.
That's quite expensive,
Mm-hmm.
so don't do it. So you don't have specific rules on merging like a zipper or forming a rescue lane, or maybe we can just state that in the Netherlands you're counting more on the common sense and the courtesy of the drivers than we do in Belgium.
Now, I'm not going to comment on that, but where we might be a bit more stricter is the obligation to report. Officially, a damage you cause to someone else must be reported to the liability insurer within 3 days after the accident. But in practice, unfortunately, this is not always done. If no accident report is received by the insurance company, of course, after an insured is requested to report the accident, liability will be judged based on the documents available. For example, a European accident form that has been signed by both drivers. And if this is not available, it is up to the demanding party to provide proof of an unlawful act of the other party with, for example, witness statements or a police report.
Well, legally, following a royal decree, you should report an accident at least within 8 days to the liability insurer. However, in that decree, it also is stated that the insurer may not claim this time frame was not respected by the policyholder if the accident was reported as soon as reasonably possible. Because reasonably is a rather broad notion, therefore, we tend to wait longer for the accident report form from the policyholder before we will judge on liability. We often wait longer than those 8 days.
Okay, well, in the Netherlands, we have an active claim settlement policy, and that policy was created with the aim of settling a damage as quickly as possible. So this means that the insurers have made an agreement to actively approach victims if liability claim is reported by their insured. So that's why we decide maybe faster than in Belgium.
Yeah, in Belgium, we are not that proactive, actually. We tend to wait until the claimant comes forward.
Well, another frequently asked question I would like to address is the out-of-court settlement fee. According to Article 696 of the Dutch Civil Code, reasonable cost to determine damage and liability, and that's, for example, engineer's cost, and reasonable cost to obtain indemnification out of court can be claimed by the victim. Cost must meet the dual reasonable assessment, and that means that it must be a situation in which it is reasonable to incur cost, and the costs themselves must be reasonable. In case of cross-border claims, it is mostly considered reasonable that the victor assigned a representative, like a legal aid insurer. To avoid discussion about the reasonable amount, the Dutch MIB agreed with Dutch legal aid insurers an amount of 120 euro per case for cross-border claims. Another agreement that was made with professional representatives and owners of fleets consisting more than 10 objects to one owner, and professional representative who made it their profession or business to recover damages on liability insurers. These representatives must have registered with this agreement by written registration, and the amount according to that agreement is €80 excluding VAT per case.
Well, such a fee is not claimed in Belgium, although I want to mention that we do have an indicative table. This table is drawn up by magistrates and police judges. It is regularly updated about every 4 years and serves as a guideline on settlement fees. It will be mentioned later on as well. But what we do have in common is a mechanism to protect pedestrians, cyclists, and any other unmotorized road users, correct?
Yes, we do have that. And it's a complicated, even for Dutch people, sometimes hard to understand. In the Netherlands, this is controlled by Article 185 of the Road Traffic Act. This article contains protection laws for unmotorized road users against motorized road users, and for injury claims mostly relevant for pedestrians and cyclists. In accordance with this article, liability for damage caused to persons or property not transported by the motor vehicle, for example, road furniture, rests with the owner or holder of the motor vehicle, unless it is made plausible that there is force majeure, intent, reckless bordering on intent, or contributory negligence. And that is according to Article 6101 of the Civil Code. So that has to be proven. The unmotorized party only needs to prove his or her involvement in the accident, and when the motorized party fails to provide evidence of the aforementioned, this motorized party is fully liable towards the unmotorized claimant, including recovering parties on behalf of the victim, like health or social insurers, employers. Unmotorized victims are additionally protected, and assuming that there is no force majeure or recklessness bordering on intent or intent, the victim older than 13 years is still entitled to receive compensation for 50% of his claim when the accident is fully caused due to his own mistakes. And for victims younger than 14 years old, this is 100%. Only victims are entitled to this. Recovering parties are not entitled to receive the 50 or 100% when their unmotorized insured fully caused the accident. The additional protection to compensate the unmotorized victim's damages, even when this victim made all the mistake, doesn't mean that the motorized party is unable to claim his damages from the victim. Example, a 20-year-old cyclist causes vehicle damage toward a motorized party and is suffering from injuries himself. The bicyclist is entitled to 50% of his damages, and the motorized party can claim 100% of his vehicle damages from the bicyclist. 100% is not always possible. Because it's such a complicated matter, the Association of Insurers has provided a detailed explanation regarding the application of this article. Unfortunately, it is in Dutch, but if you do want to have a look at it, Ayla will share the link to this in the chat.
I'm very happy that you were first to explain this article. Now we can just say it's exactly the same in Belgium. But unfortunately, it is not exactly the same. In Belgium, we have Article 29 bis, which protects any person other than the driver of a motor vehicle. So this can be, as earlier mentioned, a pedestrian, a cyclist, a passenger in a car, so-called vulnerable road users. In case of an accident between a motorized vehicle, in Belgium it includes trains and trams, and the vulnerable road user, the insurer of the vehicle involved must pay for the damages to the vulnerable road user, and that is regardless liability. There's only one exception, and that is if you intentionally caused the accident and are older than 14 years. The damages that have to be compensated by the insurer of the vehicle are, first, the bodily injuries, including physical, moral damages, and of course, medical expenses. And secondly, the clothing damage, including so-called functional prostheses such as glasses, hearing aids. Any other material damage to be claimed is in connection to the liability. So we can state the main differences on a high level here are that the motorized vehicles in Belgium include trains and trams, and that we do not apply any percentage in case the victim is in fault. Let's move on to another similarity, the loss of use. It can be claimed in Belgium and the Netherlands, correct?
Well, yes, it is correct, but in the Netherlands, it can only be claimed for commercial vehicles. For private vehicles, only reasonable rental costs or costs for public transport can be claimed. For rental costs, the downtime of the damaged vehicle is considered, so a maximum of 80% is being reimbursed. And for commercial vehicles, it is calculated in accordance with a formula agreed with organizations of, for example, leasing, rental, coach, transportation, or taxi companies. And on the website of Nivere, an extensive explanation in Dutch for what has to be taken into account for the calculation of loss of use for trucks and trailers can be found. And Ayla will send this link to you all in the chat if you would like to have a look at it for yourself.
In Belgium, it's a bit different because of all the vehicles, they can actually claim loss of use. And the earlier mentioned indicative table can be used to calculate the loss of use. It makes a distinction based on the vehicle type. So a passenger car will cost 20 euros and a van will cost 40 euros. And all these amounts are mentioned in the table. The number of days of the loss of use to be calculated is mentioned in the engineer's report.
Well, back to something that really differs, statutory interest. In the Netherlands, this is immediately due and payable if it's due to damage from the date of the damage until the date of the payment, even if the costs have not yet actually been incurred. The percentage is determined by the government every 1st of January and 1st of July. And per the 1st of July 2023, it has been set to 6%.
So it will change rather soon. It will go up, I guess. But in Belgium, out-of-the-court settlements of material damages interests are not claimed, and thus we don't pay them out.
Let's go to total loss. In case of total loss, the replacement value after deduction of the value of the remains can be claimed. However, it is not possible to claim the price as new, even if a relatively new car is involved, which has only been in use for a short time. The damage experts determine the current value of the current car wreck by having bids submitted by interested buyers, and the highest bidder will pay the salvage value of the vehicle to the owner and becomes the new owner of the vehicle. Tax for passenger cars and motorcycles, the so-called BPM, paid when buying a new car or importing a vehicle from abroad, remains in the value of the vehicle. The remaining BPM is calculated according to a depreciation table. Because VAT is not calculated over this tax, Dutch total loss report often looks pretty complicated, but necessary to calculate the correct VAT amount within the value of the vehicle and wreck. Is this the same in Belgium?
No, the calculation is done a bit different, and I'm happy to say it's less complex for us. The difference lies within the BPM. The calculation is as follows. The value before the collision plus the VAT calculated on that amount, minus the value of the car wreck. And additional costs such as taxes, loss of use, can also be claimed in case of a total loss. We noticed that in case of a total loss, the reimbursed amount tends to be higher in Belgium than in the Netherlands. So if you're planning to crash your car, I would advise you to do crash it in Belgium. What about the documents needed to settle a vehicle damage, Linda?
Well, in the Netherlands, there is no obligation to repair, so a repair invoice is not required. Depending on the age of the vehicle and or the damage amount, detailed damage calculation of the repairer can be accepted. If not, an engineer can be appointed. In case the third party assigned the engineer, the costs have to be settled by the liable party. And VAT also must be settled, even if the vehicle has not been repaired yet.
This is the same for Belgium, except for two small differences. Only if the engineer is appointed by a legal aid insurer, the costs will be reimbursed. And if VAT is claimed, we would need a signed VAT statement of the claimant. I don't think that's mandatory in the Netherlands, right?
No, that's correct. The VAT statement is not necessary in the Netherlands. We tend to accept the information from the victim or its representative if VAT can be deducted or not.
Okay.
Well, Matthias, you were very eager to talk about obtaining police reports in Belgium, but let me go first. In case of accidents with only material damages, the police generally don't go to the accident site. Most of the time, parties involved will be advised to fill out an accident form together. And in case there are issues, think of translation problems or heated discussions, they sometimes do come down and help fill out an accident report form. And if necessary, they can also draw up a report. This report is sent to a central office of the Stichting Proces en Verbaal insurers, but we as Van der Meijden also can request digitally for that report. In Belgium, I know it's different.
Yes, but like in the Netherlands, the police normally do not intervene in cases where there's only material damage, unless there are suspicions of alcohol or drug intoxication. If, however, a police report is drafted, it can take a very long time to obtain this report. It can easily take 1, 2, or even more years. And it was this point, Linda was very eager to point that out, that actually these waiting times are normal in Belgium. However, we have seen some slight improvement since Verpais was launched in 2016. Unfortunately, for now, this system is only accessible for to Belgian insurance companies. But we hope that in the future, TPAs such as Van der Meijden are granted access as well in the future. And we are already nearing our last topic. The delays of public transportation. It's one which does surprise our foreign colleagues and customers from time to time. The delays of the public transportation services caused by an accident or a wrongfully parked car can be claimed in Belgium, and I must warn you, these amounts can be pretty high. As Linda can confirm, delays of public transportations cannot be claimed in the Netherlands?
No, indeed, this cannot be claimed in the Netherlands.
This makes us unique.
Yeah.
So we'll pass on the word to Isla, I think.
Yeah. So I guess that was the end of our discussion today. Thank you very much, Linda and Matthias. I can't speak for everybody who's attended our webinar, but I sure have learned a lot from the both of you. So much appreciated. And of course, I want to thank everybody for joining this morning as well. If you have any questions, please feel free to put them in the chat. I saw we already had a question earlier, and I want to thank our colleague Simon for responding to that question already. Yeah, So if you have any questions, please go ahead. And if any questions happen to arise after the webinar, please feel free to contact us at marketing@vonemeide.com, and we'll be sure to get back to you or put you in touch with the right contact.